This video is going to cover methods of avoiding following a binding precedent by the courts. So let's have a look at the big picture first of all. The previous video had a look at the key features of judicial precedent. Today we're going to have a look at ways of avoiding a binding precedent. So there are, broadly speaking, two different sets of methods. There's generally avoiding, where a higher court avoids following the decision of a lower court, and the sorts of methods they can use include overruling and distinguishing. There are also methods which allow individual courts to avoid following their own previous decisions, namely the practice statement for the Supreme Court and Young and Bristol Aeroplanes exceptions for the Court of Appeal. So previous questions which have come up in the AQA law exam, it's always question number 11, and it's asking you things like, I can outline the Supreme Court and the Court of Appeal avoiding following precedent, 2 ways that judges can avoid following in general. So you're always asked either specifically to do with particular courts, either the Supreme Court or the Court of Appeal, avoiding following precedent, or looking more generally. And we're going to look in a bit as to how exactly you're going to attack those questions. So even though it's true that generally judges will try and follow the decisions of judges which have come before them, sometimes it is important for a judge to avoid following a precedent which has been set before, and that judge has to be able to avoid following that precedent. So the first method that we're going to have a look at is distinguishing, and this is the main method that courts use to avoid following a binding precedent, because what the judge is saying is that the facts of the case are sufficiently different to the facts of the case already decided, and if they are, the judge doesn't have to follow the precedent set before. So this can be seen in the case of Balfour and Balfour and followed by the case of Merritt and Merritt. So Balfour and Balfour was from 1919. In this case, the husband and wife had an agreement that the husband would pay the wife some money each month. When they separated, the husband stopped paying the money, and the court said that it was not a legally binding agreement, because agreements between husbands and wives were not legally binding. It was a social and domestic agreement only. Balfour and Balfour was distinguished from the case of Merritt and Merritt, because here in Merritt and Merritt, the couple had already separated when they made their agreement, and the husband agreed to sign over the home if the wife continued to pay the mortgage. The court held that the couple had already separated, and therefore they intended to create a binding agreement. The other difference in Merritt and Merritt was that the agreement was written down and they'd both signed it, which showed that they intended to stick by it. So let's look now at overruling. This is where a higher court doesn't follow the precedent set by a lower court or by itself in an earlier case. But that is the key thing. It's in a different case. And the way that you know that it's overruling is you're going to have 2 different case names. So, Pepper and Hart was overruled by Davis and Johnson. In this example, the House of Lords overruled its earlier decision in Davis and Johnson, where it said that it couldn't look at Hansard to find out the intention of Parliament. The later case of Pepper and Hart overruled this, went against it, and said that they could look at Hansard. And this is also a use of the practice statement that we'll look at in a bit. Hansard is an accurate word-for-word description of what is discussed in Parliament. So reversing is not something that you necessarily definitely need in each and every answer. It's an enhancement to your answer. So it's going to be the last thing that you write, only if you've got a few seconds left and you're trying to fill them. It's not going to be the main focus of an answer. So reversing is where the same case goes to appeal and the appeal court changes the decision reached by the lower court. This can be seen in a case called Jolly and Sutton. in this case, young boys found a boat which had been abandoned by the council, and they were hurt whilst trying to repair it. The Court of Appeal said that the council weren't negligent in leaving the boat there because it wasn't foreseeable that these boys would try to fix it. The Supreme Court reversed that decision and said that actually it was foreseeable. So reversing is when a decision is changed on appeal, so it's the same case. Another enhancement is disapproving. And the reason why it's an enhancement is because this is not a method of avoiding precedent. This is where a lower court is saying in obiter dicta that they don't like the previous decision of a higher court. Remember your hierarchy of the courts. Lower courts can't go against the decisions of higher courts, so they have to agree and adopt their approach. But they can say in obiter dicta that they don't like it. And sometimes this might persuade a higher court to change the decision in a future case. So let's look at the Supreme Court and the Court of Appeal and how they can avoid following their own previous decision, because generally they are bound to follow their own previous decision. But if a later case with similar facts comes up, they generally have to be decided in the same way. However, the exception to this is with the use with the Supreme Court of the practice statement. This was created in 1966 by Lord Gardiner, so that the Supreme Court, or the House of Lords as they were known then, could depart from their own previous decision when it appears right to do so. They've only used this very, very occasionally. It's 50 years old now, and it's only been used 30 times in that time. So we can see the use of the practice statement, as I said previously, in the cases of Adyen and Breck. This was overruled by British Railway Board and Harrington, which stated that the occupier owes a duty to a child trespasser. And also the practice statement can be seen in Davis and Johnson, where the court said that you couldn't use Hansard when deciding cases, and this was overruled by Pepper and Hart, so that they now can. So all of those cases were decided by the Supreme Court, and in the later case, British Railway Board and Harrington and Pepper and Hart, this was them going against their previous decision and changing their previous decision. So the Court of Appeal has their own particular method of avoiding its own previous decision. It has less scope, however. The Court of Appeal can only avoid following its earlier decision if it's made in error, or if there are two conflicting earlier decisions of the Court of Appeal, the court can choose which one and override the other, or where the decision conflicts with a later decision of the House of Lords, the Supreme Court. And the Court of Appeal can also depart in criminal cases if someone's liberty is an issue, as in R and Spencer, or to ensure justice, as in R and Simpson. The use of Young and Bristol aeroplanes can be seen in the case of Parmenter. Remember, this is where the court decided that for Section 20 of the Offence Against the Person Act, the mens rea required foresight of some harm. In the case of Parmenter, there were two previous decisions which conflicted, and Parmenter, the decision was reached that there was the requirement of the foresight of consequences. So Young and Bristol aeroplanes was used to make the decision in R and Parmenter, is what you need to know here. So the way that the question can come up is two different ways. You might be asked a question where you're asked generally about avoiding. So outline two ways that judges can avoid following precedent. You would start with the general methods, discussing overruling and distinguishing, and the others if you have time, and then move on to the ways that courts can avoid following their own previous decisions. And that's the way that you would split your time with that question. The other way that this question can come up is you might get the specific question. So it might ask, outline how the Supreme Court and the Court of Appeal can avoid following precedent. You'd start with how they can avoid following their own previous decision, and then move on to how they can avoid following precedent from lower cases in general, overruling and distinguishing.